Madam Chair. Good morning. I swear I'm going to go all electronic one day, but it doesn't look like that anytime soon. I want to begin by first saying thank you to the chairman for allowing me to lay out a bill that is, as you can see by the number of people in the room, controversial. I'm so
We're going to talk about it, right?
I'm so glad I could wake everyone up on a Monday morning with this little bill. I want to also just kind of as the groundwork lay out my passion about private property rights. You know, we've had a number of things happen, and I can tell you, we all talk about when a president is shot, you know where you are on the road, or you know where you are in your life. I can remember when the Kelo decision came down. I can tell you exactly where I was when I got the phone call. And I was literally in Bastrop, Texas at a stoplight. And Jimmy and I were driving on a trip. And I had done economic development work for a number of years, and I knew how terrible that decision was. Hence, there were a number of bills when we came back to clarify the Kelo decision here in our state. And Beverly Woolley first led that, and her House Bill 2006 was eventually vetoed by the governor, and that was in 2007, very interestingly, trying to find that balance of where private property rights are and making sure that it's not too expensive to condemn property. And that led us to a series of bills, and eventually SB 18 passed. And I want to thank Craig Estes and my former desk mate Charlie Guerin for the efforts that they made, and I think really clarifying and giving some certainty to this process that we have. During that SB 18, I put an amendment on. It's not always fun and easy to go against your desk mate, but something that I passionately believed in, and won that amendment on the floor. It's a little bit different tact, but it was still trying to give even more rights to the property owner. That was eventually stripped in conference. Last session, I filed HB 20, which was a very similar issue. And so I've been struggling. And every time I file a bill, I notice the room, you know, with private property rights, it fills up with people that say, we can't do this because. And again, I think that one of the most important tenets of our freedom is your right to own property. And I was thinking about this morning with the rain and everything that was coming on, that soon our roadsides will be dotted with the beautiful wildflowers and bluebonnets and Indian red blankets and things. And I will tell you that my career has been dotted just as many times with people who have gone through this process, and it was a terrible process. And so I'm going to lay out a bill in the spirit of that. Like the family that came to see me who was dealing with, you know, and it's not to say these are bad people. We love the oil and gas industry, but a pipeline company who already had an easement through their property, but had decided that they were just going to go diagonally across their property instead of following the other footprint. And the lady looked at me and she said, it's been such a bad experience that I'm just going to sell this little farmstead and get out of it. I never ever want to own property again. I never want to go through that again. And it shouldn't be like that. So Senate Bill 474 actually takes a tack that other states have done, which forces condemners to reimburse property owners for attorney fees in eminent domain proceedings where it is determined that the condemner's offer for the property is 10% or more lower than the amount determined by special commissioners or the court. And so basically what it says is that the spirit of this bill is to say, if you go through everything from the initial offer, which might have been declined, and keep in mind 85% of the cases today are settled on that initial offer. But if you decline that, and then the final offer, which does require an appraisal, is rejected, then you go to the condemnation process, which is first administrative, which is with the 3 special commissioners. And then, you know, through those, if at those condemnation practices, if it's determined that the offer was not really and truly fair market, I mean, you know, through that process they decide that it's 10% higher, that you got lowballed, then your attorney's fees can be reimbursed. Different states do it differently. You know, Florida is that 10%. In California, it's determined by the court. It's kind of wide open. There's some case precedent there. You know, Arkansas is 10% on highways and 20% of corporation or water association. You know, Arizona's kind of without a percentage. And so everyone does it differently. Some like Ohio, restricts attorney's fees. And so it varies throughout the different states. I think this is a great discussion to have. It's interesting. If you ask me who asked me to carry this bill, nobody. In fact, my staff laughed and said, you came in one day, threw open the door and said, we cannot discourage the little people from accessing the courts because they're scared of attorney's fees when it comes to taking their home or their property. And, you know, I had someone stop me as I was walking in going, oh, I'm so sorry, Senator, I have to be against your bill today because I represent a water authority and all we do is take a little strip of land, and so a 10% variance. I mean, we could craft this. In some states say, you know, it has to be over $25,000 on a variance. I get it. But if you're going to take my property and go diagonally across my property and render that piece of property, whether it's in Fayette County or Colorado County or Grimes County or anywhere, and you're going to render that property no good, you have to have some way to get attorneys involved. And you're scared because the common person cannot afford it. And so I would say this bill's for the average Texan. And I don't want an attorney's protection fee. In fact, some of the attorneys said, all the attorneys are against your bill. I go, well, great, nobody's for it but the average Texan who says, you know, if my initial offer and my bona fide offer are something that I can't accept, then can I afford to roll the dice and access the courts? It's an initial. I have 2 substitutes not offering today. I would love to hear, and I'm going to listen to the people and that are here to testify today, and I'm very respectful about their stance. But one of the best things that I think happened out of SB 18 was the report that made everyone who had eminent domain authority have to file with the Comptroller's office. Susan Combs, Comptroller Combs, put out that initially that's over 9,000 entities in the state of Texas. As you pare it down, it might be closer to 5,200, working with Comptroller Hager. But regardless, somewhere between 5,200 and 9,000 entities, including private corporations and public, have this authority, and it's a huge authority. And lastly, let me say, that again, as a product of SB 18 and having to make this a requirement to report these things, we now know over 200 statutes carry eminent domain authority across a broad spectrum, whether it's property code, local government code, all the way across. So it's a huge authority that we give not just to our government, but we give it to private corporations to take people's land. This bill, the spirit of SB 474, is just to say, if you need to, you can access the courts. And if you were wronged, those fees will be paid by those that wronged you.
Questions of Senator Kolkhorst? All right. Yes, Senator Zaffirini.
Senator Kolkhorst, looking at the fiscal note, it says that there's no fiscal implication to the state. I don't understand how it couldn't have a fiscal implication to the state.
I haven't asked on that, and certainly you would say, well, maybe the state's one of the better actors and our initial offers are pretty good and we don't have to go to court very often. And again, as I say, 85% of the cases are settled on the initial offer. Now, you'll hear some hypothesize the reason that it's settled so quickly is because people are confused, dazed, scared. They don't know how to access all the processes. So, Senator, I don't know about that, and I certainly, as a good appropriator as you have been, I'll question that as well.
I would suggest it could be that they're just utilize current staff that's taking care of the, the attorneys and so forth. So it's not going to be additional cost. It's just current staff doing the work.
Strange.
Yeah, we'll look into it.
And Madam Chair, if it pleases the committee, we've worked on and have some access to what other states have done, and it's really interesting that most states have some tolerance level, and it varies. Some states even cap what attorneys can recover as well. And so maybe I can just make the whole world mad as maybe I could craft a substitute and everyone could be mad, and then you'd probably have a pretty good bill.
Senator Kolkosz, do you want me to call up all of your invited testimony? Do you want everyone up here? We have Justin Hodge, Justin Spillman, Richard Jennings. These are all invited, right? Mm-hmm. And Patty Myrick and Luke Ellis.
Yes, ma'am, I think so.
Okay.
Is that okay with
if
you?
I've called your name, please come forward. Sure. All right. Let the record reflect that Senator Creighton is here with us. Thank you. All right. Mr. Hodge.
Mr. Ellis, thank you.
All right. You may proceed.
Good morning. My name is Luke Ellis. I'm an attorney, and I represent Texas landowners facing condemnation proceedings. And I'd like to start my comments by giving you all a very real-world example to think about. A landowner buys a piece of land for $300,000. A landowner then builds a home on that piece of land for $200,000 worth of construction costs. That landowner's all in on that piece of property for $500,000. A governmental entity comes to take that land from the landowner for a project that will benefit our community. The governmental entity offers that landowner $300,000. That landowner knows that number is low because that landowner knows what they bought the land for and they know what they built the structure for that they now live in. The land's been taken by the government. That landowner seeks help from a lawyer just like me. We fight the case typically for a period of 1 to 4 years. At the end of that period, we go through a jury trial and the jury awards $500,000, exactly what that landowner is owed. The question I pose to this committee is, has that landowner been made whole? Has that landowner recovered in full for the benefit that their land has provided to our entire community? The answer under the Texas system as it exists today is a very definitive no. And the reason for that is because that landowner whose land was taken, who received a grossly low offer by the condemning entity, has to pay a lawyer like myself to represent them during the course of the proceedings. That landowner also has to hire experts to counter the experts by the governmental entity that came up with the low appraised value for their property. That's a very significant cost in a Texas condemnation proceeding, typically at least $20,000 to $25,000 at the bare minimum. Has that landowner been made whole? The answer is no. I'll give you 2 examples that our firm has been involved with just in the last 12 months. We took a case to jury trial in Wichita Falls 4 weeks ago. It was a high voltage electric power line case. The initial appraised offer to that landowner was $54,000. We looked at all of the credible evidence in that community to determine what the impact was. We fought the case for nearly 3 years, got it to a jury trial in Wichita Falls. We presented evidence based on strong appraisal testimony that the damage was $393,000. A jury in Wichita County awarded the landowner every dollar of $393,000. Was that landowner made whole? No, because more than 35% of the cost associated to achieve the result of $393,000 had to be paid either to our firm or to the team of experts that had to be hired by the landowner to fight against the grossly low offer made by the power line company. We had another case, a pipeline case, very similar. Very low offer, very high recovery. Once we got through the jury trial, the landowner in that case recovered about 55 to 60% of the actual damage that the jury found was attributable to the property. They were not made whole, which brings us to the fundamental problem that I believe Senate Bill 474 is intended to address. Under the current system in Texas, if you win as a Texas landowner before a jury of your peers, do you really win? I don't think so. U.S. Constitution, Fifth Amendment, requires just compensation to a landowner whose property's been taken. Article 1, Section 17 of the Texas Constitution requires adequate compensation to a landowner whose property has been taken. And there's a reason for that, because their property is benefiting all of us, the community. But in Texas, as the system exists, you don't get just compensation or adequate compensation. You get adequate compensation less the costs it takes you to achieve adequate compensation. And that's not a fair system for Texas landowners. I would tell you there are a number of policy reasons for you all to consider this bill. One, right now, condemnors, governmental entities who take property, have absolutely no incentive to treat landowners fairly. They're in a business. Their business is to build a project. Their business is to build that project as cost efficient as possible. There is no penalty for them to make low offers to start. So what do we often see from power lines, pipelines, and other governmental entities? We see very low offers so that they can try to wash away a strong percentage of folks who simply don't want to fight or are overwhelmed with the thought of fighting. And there is absolutely no penalty for condemning entities to do that. The second thing we often see once the proceedings begin is condemnation abuse, the ability for them to intentionally run up costs, legal fees, or expert fees associated with a landowner challenging and exercising their constitutional rights for fair compensation. So I'd ask that you all think about this bill, give it very serious consideration, because we think it would be the first and very strong step in trying to balance the scales.
Thank you, Mr. Ellis. I have a question for you. It sounds like you handled quite a few of these types of cases to jury trial. Is that correct?
That's correct.
My instinct would tell me that jurors are probably lean towards siding with landowners for at least actual damages when confronted with the hard evidence. Is that a fair statement?
I would disagree with that. I would tell you that the framework that has been created over 100 years of Texas jurisprudence limits the ability for a landowner or their counsel to make sympathetic or emotional pleas to a Texas jury. There are very specific things we can and cannot say when we get in front of a jury, and including the voir dire process, which allows both sides, including the condemning entity, to pick out 6 fair and reasonable-minded jurors. I wish I could say in front of every jury, my family's owned this for 6 generations and they ought to be paid a heck of a lot of money because they don't want to give this up. Texas law prohibits us from saying that or making other types of impassioned, emotional pleas in an effort to increase the recovery for landowners.
Are you able, though, to give the facts as far as what somebody paid for the land, what they're now being offered for the land, the fair market value of the land?
Depends on each case. If someone purchased the land many, many years ago, that purchase price would have no indication of fair market value in 2015, so that wouldn't come in. We do get to talk about what the other side has appraised the property for, but you have to remember, when we do a condemnation trial, we are bound under what I'll call a hypothetical context. The law requires us to establish one day, which is the date of taking in the case. And what we have to do, and what the appraisers are charged to do, is go through this hypothetical analysis, which is what would a buyer have paid for that piece of property before the project's taking on that magic day. Then they have to measure what would a buyer now pay for the property after the taking. So if it's a high voltage power line easement or pipeline easement or water line easement, how much less would a buyer pay because it's now encumbered by that negative feature? The difference between those two numbers is what you can recover.
Well, Senator Kolkhorst, I'm starting to agree with you that this sounds like it's a really tough process for the property owner. Thank you for sharing that with us. All right, thank you. Yes, ma'am, Senator Zaffarini.
Thank you, Madam Chair. Senate Bill 474 treats public and private condemning authorities the same. Do you agree with that perspective, or do you think they should be treated differently?
I generally agree with the perspective that they should be treated the same. And this is from someone who's on the front lines. We represent landowners every day, every week. This is what we do. I wish I could tell you that I only see the aggressive and what I would characterize as abusive practices on behalf of private condemnors, but we do see it on behalf of public entities as well. You raised a question earlier about what happens with the costs associated with moving forward with these projects. I would argue that if we made an initial fair offer, I think you would actually see costs go down. I think you would see the number of lawsuits involving condemnations go down. I think you would see lawyers like my law partner and I probably have a little bit less work because landowners would get a fair offer to start and would be less motivated to move forward and to fight.
And that was my next question, that given your experience of the bill passed, what did you believe the fiscal impact would be on the state? And you're saying it might be lower?
Yes, ma'am, I believe that to be the case.
Thank you. Thank you, Madam Chair.
Thank you, Senator Zaffarini. Justin Hodge? Proceed.
Yes, Senators, thank you for having us. My name is Justin Hodge. I'm also a law partner with Johns, Mars, Ellis, and Hodge. And just like Mr. Ellis, day to day. I do this for property owners all over the state of Texas. In fact, one of my former clients that our law firm was able to represent pro bono is a church in the greater Houston area, and I've invited the pastor to talk with the Senate committee here today on that. I would like to back up and offer just a personal testimony because I think this is what brought me to this chair and being a lawyer helping landowners all over the state. My family had its property taken from them. It's a family ranch. This was up at the Bell-Williamson County line, and my grandfather, who's now deceased, so I get a little emotional, and I apologize if I do, but as you might imagine, like a lot of these Texas landowners, the land means a lot. My grandfather had spent his lifetime drilling dozens and dozens of water wells on our ranch looking for water in an area here where drought is ridden and you're trying to feed your livestock. And back then, the communities weren't very large. Now the water demands are for the communities. My grandfather probably drilled more than 70 water wells on our ranch. After he passed away, my dad was fortunate enough to discover 7 commercial-grade water wells, and we actually contracted with several communities in the Central Texas area, the village of Salado. We were working with contracts south of us towards the cities of Georgetown. And in 2006, the state of Texas, TxDOT, decided that it wanted to build a safety rest stop right on our ranch. They wanted 28 acres, and in fact, they were taking the property where 6 of the 7 commercial water wells existed. Well, that was a shock to us. We begged and pleaded with TxDOT, said, move the safety rest stop. If you've driven I-35 recently, just north of the Bell-Williamson County line, you'll see those safety rest stops are there. And capped in the bar ditch are 6 commercial-grade water wells. For 6 years, my family fought that lawsuit. It went all the way to a jury trial in front of County Court at Law No. 1 in Bell County. The state of Texas offered us what they considered a fair offer. They offered us $350,000. That included no compensation whatsoever, $0 for the groundwater under our property. The Attorney General took the position that we as landowners did not own the property own the water underneath our property, contrary to more than 100 years of case law in Texas. Now we know the answer to that because our Texas Supreme Court, Justice Heck, issued an opinion in 2012 in the Day case saying that landowners, in fact, do own your water, but at the time, that opinion did not exist. A jury of 6 people in Bell County who considered the fair evidence awarded our family $5.8 million as just compensation for the loss of the water. And you would say, well, aren't you made whole? Isn't your family made whole in that situation? And the answer is no. The reason why is I look back to my grandfather, and we had to pay as a family more than $2 million in attorney's fees to get that $5.8 million. That doesn't include the expert costs associated with that. That was money my grandfather had worked hard for to pay for college educations for his great-grandchildren, my father's grandchildren, and my children. And so I stand here with a passion and really do believe that this is a bill that would help landowners like my family, landowners like Pastor Jennings, who is sitting opposite me, who have to bear this huge cost for society as a whole, as a community. And it stops the abuse because in my family's instance, there was an attorney general that was working really hard to try to run counter and create new law for a policy reason that may not have even been recognized by the leaders of our state and ultimately was not the law of the land. And we see that from day to day. I will only offer one other case study, and that is a gentleman out in Beaumont, Texas. I had lunch with him last week. His name is David Holland. Mr. and Mrs. Holland own property, and there's a fairly well-known Texas Supreme Court opinion that was issued recently in their case. They fought Denbury Green Pipeline Company, and our Texas Supreme Court issued a very stern opinion stating that Denbury Green Pipeline did not have the power of eminent domain. And there's been some reform with the Railroad Commission recently as a result of that. Mr. Holland sat across the table from me, and we sat united because he shared with me that he has spent over $1 million fighting Denbury Green Pipeline, all to the end that Denbury doesn't have the right to take his family's ranch. But he had to spend the money, and he's not receiving just compensation back for that money that has been spent as we sit here today. So with that, I thank you for your time and the opportunity to be here.
Thank you, Mr. Spillman. Any questions? All right. Richard Jennings.
I'm Pastor Richard Jennings, River of Praise Church in Tomball, Texas, also past chairman of the board of the Greater Tomball Area Chamber of Commerce. We were severely impacted by eminent domain regarding the Grand Parkway. It cut through the middle of our campus. We lost 25% of our campus, a third of our new campus expansion, and the new campus expansion, we lost over half of our parking. The way the proceedings went for us, the initial offer from TxDOT ended up being what we settled for was 2/3 greater than the original offer. I was a quality engineer at Compact Computers. Data is a big thing to me. I extrapolated property values along the freeway that was dissected by the Grand Parkway, and the numbers just didn't add up. And we were forced to hire not only Justin Hodge, but another attorney firm and professional appraisers to look at our property. And it just didn't make sense to us, and so we had to take it to court. The conflict with us and myself personally as being the